Welcome to Queen Mary. My name is Peter Aldridge. I'm one of the professors in the law school here. Tonight is one of the highlights of our academic year, which is the Law and Society lecture. If truth were told, it actually started life as the Law and Society lecture, where X was the name of a publisher. After a while, the publisher stopped giving us money, and we stopped naming the lecture after them. I'm sure there's some sort of lesson there. The lecture in the past has been given by Sir Peter Gross, Sir Ross Cranston, Shami Chakrabarti, Clive Stafford Smith, and a whole bunch of other luminaries, and we should compile a list before everybody forgets them all. Tonight's speaker is a brilliant tax lawyer, and half of me really wanted him to speak on the meaning of sort of, deductible allowance or something for the purpose of this capital allowances thing, on which I'm sure he's an expert. But he is also a blogger and a writer and a tweeter of enormous significance and an activist. And he's going to speak to us tonight on the subject of the lawyer as political actor. Would you please welcome Jolyon Maugham QC?
A very long list of luminaries, and now me. And I wouldn't have come along to speak about capital allowances because it's very, very boring, much less interesting than this. If you're ever asked to speak about something, and for me that's quite a rare experience, I'm much more often asked not to speak about something, it's a good idea, I think, to start by asking why it is that you've been invited to give that talk. There are other organisations in the United Kingdom that have a far longer history of engagement in the cause lawyering field than I do. The Legal Action Group, the Public Law Project, Liberty, headed of course famously by Shami Chakrabarti, and there are also specialist single-issue litigators like Client Earth. And alongside those practitioner-led groups, there are many organisations who are not focused on legal action, but who routinely take legal steps to advance the interests of their client groups. And perhaps the most obvious example of this is trades union. And I think of some trades union, the IWGUB, GB rather, which are very, very activist in taking action to pursue the interests of their client groups. And then alongside those speakers who could also have talked to you about cause lawyering are the very many people who are funded to provide or who fund thought leadership in this field of legal activism as commissioners or as publishers or as academics or as writers. The Baring Foundation is doing a lot of funding and a lot of publishing on the use of law in the voluntary sector, which is a particular area of interest for it. I mention all of this for a couple of reasons. One is that many of you will have come along for a neutral survey of good practice in this sphere. You won't get it this evening, but you needn't go away wholly disappointed because I've given you some very good sources from which you may extract it. And another, to be fair, is by way of tacit apology for at a seminar I gave on this subject about a month ago, I omitted to mention the very many effective other organisations working in this sphere. So that was, at least in part, tacit apology. For my part, I enjoy the advantages and I suffer the consequences of who I am. I came to what I do as a practitioner, and the practice of what I do has the benefits of that stance. It's a very applied sort of science, but it also has the short perspective of someone who is stuck in the trenches rather than the general surveying the scenes from the hilltop. What I have is my own learned experience, and it's that I want to talk about this evening. What I can speak with some authority on is how I understand the zeitgeist of what I do, but it's not going to be a good use of these next few minutes for me to spend it coughing up semi-digested tidbits that I've stolen from other people's tables. I promise you'll have forgotten that metaphor by the time you get to dinner. So what are the things that mark out my own practice in this space? I guess there are probably three. First of all, politics. The issues that I choose to engage with, the issues I consciously choose to engage with, are issues that are right at the heart of the political debate. The second is crowdfunding. I'm described fairly, I would say, as the sort of king of crowdfunding in the legal sphere. I've raised well over £500,000 from, I would guess, tens of thousands of individual donors. So I'll talk about that a little. And I also want to say a few words about the ethical component of the work that I do. So I begin with politics. My political engagement in the legal space predates Brexit. I started writing about tax avoidance, bringing to a then intensely political sphere the insights of a practitioner in 2013. There are many, many privileges that come with being at the bar, and one of those privileges is that you are able to speak about the things that concern you. If you work in a firm, your ability to do so is constrained. It's constrained really in two ways. The first way in which it's constrained is that you suffer the difficulty that the issues about which you talk may involve you conflicting yourself from acting in other matters that the firm is engaged in, or may create conflicts of interest problems for the firms at large. So there's a very famous tax avoidance case called Icebreaker. It was the Take That case. Bill Dodwell, who's a leader in the tax field, spoke out about that case. It turned out that one of his colleagues was acting in that case, and because his comments were that the case should be dropped, Deloitte, the firm for which he worked, got sued. So if you work in a big firm, if you're sitting in your seat as a student wondering what you would like to do, and if you think you might like to work in this judicial activist space, if you work in a big firm, that is very, very difficult. It's also difficult for this reason. If you work in the field of tax avoidance, as I did, and you talk about tax avoidance being morally wrong, you stand to lose more clients than you gain. Now, as I saw it, it was up to me to take the decision that I would blow up my own practice by talking about the moral aspects of work that I was very, very interested in. I thought that was a decision that I could reasonably take. But I might have felt a little dismayed if my neighbour, my desk partner, as it were, at the firm, had chosen to blow my practice up. We can make those decisions at the bar. They are very, very difficult to make if we work for a firm. Now, from writing about tax avoidance, which is what I started off doing, I was then asked by a campaigning group to help develop a case arising from the HSBC papers. We've now had 3 big tax leaks in the last 5 years or so. First was HSBC papers, the second was the Panama Papers, and then we had the leak just last week, the Paradise Papers leak. I was asked by a campaigning group to help develop a judicial review case arising from the HSBC papers. Could we construct something around HMRC's actions around the so-called Liechtenstein disclosure facility? That sounds very, very boring, but in campaigning terms it was incredibly powerful because it was a long-running amnesty that HMRC offered to wealthy offshore tax evaders, criminals, that if they came forward and they paid a sum of money that was in many cases less than the tax that they had evaded, they would escape any criminal sanction. It was, as it were, institutionalized crime does pay. You could evade your taxes, you could come forward, you could confess you evaded your taxes, and the amount of money you would have to pay would be less in some instances than the taxes you had evaded. So I was asked to construct a judicial review case around that, and from constructing a case for someone else, it is but a short hop to constructing a case for yourself. And the first case that I constructed where I was the client was the case that became Gina Miller's case. Just a couple of days after the referendum, and having read what might fairly lay claim to being the most influential legal blog of all time, a blog post on the constitutional law blog by Messrs. Barber, Hickman and King, setting out the idea that the Supreme Court came to adopt in its landmark decision. I crowdfunded initial advice, and then I crowdfunded the intervention that became known as the People's Challenge, led by Jolyon Maugham QC. Since then, I've crowdfunded a challenge to what I see as Uber's VAT dodging. I think they may have avoided £1 billion in the past and hundreds of millions of pounds in each subsequent year in which HMRC doesn't act. I'll talk about that a little bit more. I'm the claimant in that action. I've crowdfunded a challenge to the Electoral Commission's investigation into vote leaves spending returns, where we say the Electoral Commission applied the wrong legal test and also carried out an investigation that was wholly inadequate on the facts. I'm the claimant in that action. We're about to file proceedings in a case against DexU and HM Treasury to seek to compel the production of certain internal analyses of the effects of Brexit on sectors of our economy, aka the secret Brexit studies. I've acquired a terrible populist touch in these last few years, and I'm the co-claimant in that action alongside a Green MEP, Molly Scott-Cato. And next week I will be launching further legal action. Now, those cases, I've given you a brief outline of them because I want to make this point, those cases are right at the heart of where our politics is today. And it may be helpful for me to talk about what that means if you are in the space that I'm in. Of course it is a truism to say that you need to be very, very mindful of the relationship between law and politics. There's a sense, of course, in which the law itself regulates that relationship. If you are looking at a constitutional law textbook, if you are appearing as an advocate in a judicial review action, you will know very well that judges are not oblivious to the question where their writ stops and where the executive's writ starts. But judges, when they are regulating that relationship between the rule of law and the executive, are regulating to a different end. So when the law regulates the relationship between law and politics, it does so mindful of the proper constitutional division of competencies between judges and the executive. What is it for me as a judge to say? Where is it that the executive has latitude to act and should have latitude to act uninhibited by my own views as a judge? But when you use the law in an intensely political sphere, you have to use it mindful of its political impact. It's not enough for you to say the law permits it. To say that is to ask the wrong question. Putting it another way, the question, what is the political impact of using the law in this way, is a very different question to the question, is it constitutionally acceptable for me to use the law in this way? And there are some very important governance questions arising out of the fact that the way in which the law regulates that relationship between judges and the executive doesn't answer the question whether it is sensible for you to act as a legal activist, and if it is sensible for you to act, how you should act. Let me just try and illuminate that point, because I think it's quite an important point, by identifying some different reasons why it is that we might use the law in the political sphere. So, standing back, I can see, I suppose, 4 different types of case. The first is where you use litigation to change the law. So you try and strike down legislation by reference to some higher legal norm, or you try and assert that the common law is wrong in some way. And a good recent example of that type of litigation might be the Employment Tribunal's fees case that was in the Supreme Court last summer. Second type of case is litigation where you try to compel compliance with the law. So here again, recent Supreme Court decision in a case involving Client Earth. Client Earth sought to compel the government to produce a plan that complied with air quality standards regulations. So 2 categories so far: using litigation to change the law, using litigation to compel compliance with the law. Third category, litigation to know the law. Fundamentally, that was what Gina Miller's case was about. It was about answering the question, constitutionally, whose job is it to trigger Article 50? Is it for Parliament or is it for the executive? And the fourth category is litigation that pushes issues up the political agenda. In other words, litigation that is not so much about the result, or not only about the result, but is also about litigation as a campaigning tool, a way of hiking issues, as I put it, up the political agenda. The underlying case in that action is very powerful, I believe, but I also recognise that the best way for tax avoidance by US tech companies to be addressed is for HMRC, which is charged with doing it and has a budget of several £billions, to do so. And so when I act in that sphere, I act to raise the prominence of the issue so as to put political pressure on HMRC to act in a way that at least I perceive to be more cognizant with the public interest. Now, if you look at those 4 categories, there's something of a hierarchy there. Changing the law, my first category, is at the sort of chest-beating alpha male end of the spectrum if you're a lawyer. Beyond that, you have then enforcing the law, knowing the law, and using the law. But if you look at the examples that I gave you of actions in those 4 categories, you will see immediately that their political saliency, how hot they are, if you like, in political terms, is a very, very different thing to where they sit in that probably fairly anodyne legal hierarchy. Of those 4 cases, perhaps the one that made the least noise at all outside the legal sphere was the Employment Tribunal case. And yet, for a lawyer, as I say, it is right at the sort of, look at me, I'm a tough lawyer end of that hierarchy. So, the more your action is about using the law to advance political ends, the further you move from a dimension where legal judgment calls should lie at the heart of your thinking. The further you move into the political dimension in your use of the law for political ends, the less important it is that your legal thinking is right, or putting it perhaps more accurately, the less salient is the legal analysis to the question whether you ought to take that step. This can be something which is difficult to communicate to lawyers. Yes, I hear what you tell me about the law, but I'm going to do it anyway, or I'm going to do it differently from the way in which you tell me it should be done. It's difficult to communicate to lawyers because, as a profession, we are not overly burdened by concerns about the limits of our intellectual competence. We regard ourselves as knowing everything, and it is quite difficult to explain to a successful silk that his attitude on the best way, politically speaking, to do something is not the way in which you're going to do it. It requires deft handling, might be the politest way to put it. Now, in the States, there's a much longer standing tradition of activist or cause lawyering. And there's an enormous literature in the States about the extent to which legal actions, whose very raison d'etre is to bypass, on some occasions, democratic methods of achieving social change, can lack legitimacy. The literature suggests, on occasions, the presence of a happy conspiracy between judges and lawyers. The people don't know what's good for them, but we do, we the judges do, you the lawyers do, and together we'll change the law in a way that benefits them. And what the literature shows is that that happy conspiracy to change society in a way that lacks a democratic mandate can cause the law to get ahead of the political consensus and sometimes to create a rather unproductive democratic pushback. There's an awful lot of reading, a lot of learning about that issue in the States. And that's obviously an issue that in the UK we can't ignore, but nor should we ignore the very, very different context in which in the States that debate has had. So it arises in the context of a legal system that is much more powerful than ours in constraining political action. If you read a biography of Louis Brandeis, who was a Supreme Court judge and perhaps the greatest cause lawyer of them all, you get a sense of laws routinely being struck down because they offend against the Constitution. And if you read that stuff, you really are forced to ask questions about the legitimacy of the role that we give to judges. But that's not a tradition that most of us in the UK would consider that we belong to. The political ambitions of our legal actors is heavily constrained by the fact that we don't have a tradition of striking down legislative acts because they contravene some higher law. That's just not part of how we think in the UK. Prior to 1972, it simply couldn't be done. If this government gets its way post-2019, it will again be impossible. But even now, even during the currency of the European Communities Act, occasions when UK law is struck down are really quite rare. If I was giving a lecture on what good governance of cause lawyering looks like, that would lead me on to a further discussion about what successful use of the law looks like. How do you integrate your campaigning and your litigation? What legacy work do you prepare for? And that's really important thinking. And Lisa Van Haller, who's also written for the Bering Foundation, has published a case study on this issue funded by the Paul Hamlin Foundation. And for those amongst you who are looking at this from an institutional or governance perspective, that is a paper that is very well worth reading. It's all very well for you to paint yourself in the public domain as the great campaigning lawyer without being desperately thoughtful about what actual impacts your actions are having. And if you're looking at this issue in governance terms, you do have to be mindful of all of those very important broader themes. But as I say, that's not the lecture I'm going to give. I'm in the trenches. And in a sense, that's a conscious choice on my part, because I want to be where the people are. My insight, if you'll forgive me for calling it this, is that the burgeoning interest that we have in the use of the law as a mechanic for achieving social change is very directly related to a growing despondency about the functioning of our democracy. We're interested in the law to achieve social change because we're giving up on democracy as a mechanic through which we might achieve social change. Of course, the we in that sentence is a very particular we, but nevertheless it is a significant one. As citizens, we are very conscious of the need for change. We are very inspired to deliver change, but we feel a sense of helplessness when confronted with the question, how? How do we deliver change? Now, perhaps in a globalized world, that's inevitable. Perhaps the forces that have combined to deliver the world that we have are incredibly powerful. But even if it is inevitable, that doesn't make it good. And litigation provides an answer to me, and I think to others, to the question, what can I do? What can I do? And that, I think, is the question that the socially motivated lawyers amongst us should be asking about the law. That's the question they should be thinking about the law. The law as a transmission mechanism, a way of giving voice to demands for action from the people about the shape that our society should take. Now, that notion isn't perhaps as radical as it might sound, because a lot of our law is judge-made law, lawyer-made law, and the lines that that judge-made law draws embed quite profound judgments about the nature of our society. So let me take an example. When we compensate those who are the victims of negligence, we are making an assessment about how society should respond to a world in which, in the case of personal injury at least, accidents happen. We are saying that despite the inevitability of accidents in the world, only some people should be compensated, some people should not be compensated. That's a value judgment made by lawyers, and one about which different jurisdictions take profoundly different approaches. And those value judgments, it seems to me, are there and are there for us to disrupt them. I think that's right. It's naive to look upon the law as being some instrument written in dusty books that does not, by describing a society, make value judgments about what that society should be. The Good Law Project, through which I now do the work that I do, was my response to a perception that with parliamentary opposition that was unable then to put the government under real pressure, and a weakened Fourth Estate, there was an opportunity to look more to the courts to provide the checks and balances to executive power. And it looks for cases that touch upon the lives of ordinary people and which are not being litigated by others in the field. It looks for structural cases, by which I mean not merely cases affecting large numbers of people, but cases that affect the way in which the organs of society function. I am a lawyer, obviously, and that gives me a very profound engagement in questions around governance, questions around how the organs of society function, whether they are functioning right, whether they are delivering what they should deliver. And I think that thread runs through all of the work that I do. I've mentioned the Uber case briefly. Let me just talk about that in a little bit more detail because it might be the best example. There's a widespread perception that we in the United Kingdom tolerate US tech companies in particular engaging in very financially meaningful tax avoidance. We know from the academic literature that that perception undermines the inclination of other taxpayers to pay their own taxes. Why would you pay your taxes if Uber is not paying its? This all feels very unfair. It undermines trust in our institutions. Who are they really working for? And it undermines trust in our politicians, who are all too easily portrayed as being in bed with big business. And ultimately, that breakdown in trust in our political establishment and in our institutions drives a desire for revolutionary change and delivers seismic shocks like Brexit and Trump. Now, that's a perception, and that perception needs to be disrupted, but it's more than that. In my own field, a field that I know very well, I believe that perception has a reasonable foundation in reality. There is very good evidence that US tech companies pay substantially higher amounts of corporation tax in other EU jurisdictions than they pay here. Those differences can't be explained by different rates or structures or tax laws or other objective factors of which I am aware. These differences are reported by our national media, which in turn adds to public distrust in the establishment. Now, I know that there will be many of you sitting in your chairs who will see the intellectual case that I am making, who'll hear me and think that makes logical sense, but for whom it won't really resonate. Many people like us find that their experience of the establishment is conditioned by the fact that they are of the establishment. If it has worked for you, if your experience of it all your life is as reliable and beneficent, then the points I am making are unlikely to resonate. But there are many who experience the establishment very, very differently. They experience it as disengaged and existing essentially for the benefit of others. And in my own sphere, I think that experience of the establishment, the tax establishment, as disengaged and looking after the interests of other people is justified. And I want to articulate that experience for those people. I want to give them voice. And I want to articulate it for them with the only mechanic that I really understand, which is the law. And that feels to me like a moral duty. If you hear me describe what I do in those terms, and you ask yourself the question whether that is a political mission or a legal mission, now the answer's pretty clear. It's not a legal mission. There are echoes in the 1958 quote from Eleanor Roosevelt with which one of those Bering Foundation papers begins. Eleanor Roosevelt asked, "Where, after all, do universal human rights begin?" In small places, she says, close to home, so close and so small that they cannot be seen on any maps of the world, yet they are the world of the individual person, the neighbourhood he lives in, the school or college he attends, the factory, farm or office where he works. Such are the places where every man, woman and child seeks equal justice, equal opportunity, equal dignity without discrimination. Those are the places that you want to reach, that you want to touch. Can I move on now to crowdfunding? Zeus cast a thunderbolt at me on the day when I stand here as a tax silk who has done in his relatively long legal career one legal aid case and talk to you with any authority or purported authority about the effects of legal aid cuts on access to justice. I'm not qualified. It's not the world I occupy. I have no direct experience of the issues that those cuts engage. But I can talk to you about crowdfunding. And what I want to do is just briefly run through the process for those of you who are thinking about using crowdfunding before I talk about some of the difficulties of using that process. There are lots of chairs at the front. I'm not as frightening as you may think. So the process looks like this. There are a few issues that I focus on. There's Brexit, obviously, tax, employment rights, intergenerational fairness, welfare law, immigration, and housing. And I've looked at cases in all of those spheres. And if I find one that's interesting, I tend to try and take an informal sounding from a leader at the bar. The bar is very collegiate, and there is a curiosity at the bar about the work that I do. And that means that I can get very, very good people to take my call. And I describe the issue, I describe the prospective case, and if the noises are positive, I then tell the barrister what the experience of taking that case forward will look like from their perspective, because I want their buy-in before I go forward. So I think it's important that barristers are, and indeed solicitors are, paid for the work that they do. That's right as a general proposition, but it's also incredibly important if you want people to deliver consistently high quality work. So you want to pay people, but at the same time, you need to recognize that if you're living in a political sphere, it's terribly important that the work that you do is not seen as the provision of some large feeding trough for lawyers. That would be to shoot yourself in the foot. And so I try and balance those two competing considerations by paying government rates as opposed to the private client rates that lawyers doing work for private litigants would generally charge. Now, for some lawyers, that's quite a hardship. When I do work for the government, the rate is a very small fraction of the rate that I usually charge. In other spheres, it's less of a cut. I also explained to the lawyers the vagaries of crowdfunding, that there will be instances where I ask people to do work without the certainty that they will be paid for it. There are times during the process when it is just impossible to ask funders for more money, and so I say to people, look, you may have to work on without having absolute security that you will be paid. Now, if that works for the lawyer that I'm talking to, I usually ask for short form, formal advice on prospects. We know that there is no certainty about the outcome when we litigate, but if you're asking people to dip their hands into their pockets to fund a case, you need to be able to justify your choice to ask them by reference to proper formal advice. Typically, I launch a crowdfunding bid after I've received that advice, but before we issue proceedings, and usually at the letter before action stage. That seems to me to strike a reasonable balance. Earlier, and it's too speculative to ask for money. Later, and you find yourself in a position where you're ready to issue proceedings, but you don't have to stop the whole process again in order to ask for money. That having been said, I am presently part funding a rather important piece of litigation that I don't want to put into the public domain until we're further down the road. So I'm funding that money in part myself, and part of it is being funded by somebody who's in the audience this evening. If I have co-claimants, I typically offer them my own personal indemnity against adverse costs. And I do that for a number of reasons. One is that I'm typically wealthier than they are. Another is that it is true usually that I have asked them to be a co-claimant, and it's easier to persuade them to accept if they're not bearing financial risk. But more important than either of those two factors is this. I'm a silk, I'm a Queen's Counsel, and I understand the risks better than they understand those risks. And it seems to me right in those circumstances that it should be me taking those risks because I understand them. I'm uncomfortable with the notion of putting those risks that I understand better than they do on them. Now, there are lots and lots of different views about how much you should crowdfund. Lots of people try and raise very substantial amounts of money at the outset, which is typically when interest is high. So you get these never-ending stretch targets. You hit one target and then all of a sudden there's another one. It's like when you're climbing a hill and you think you're at the top and you discover that there's another peak just beyond you. I understand the temptation to do that, but there are a number of factors, I think, which argue quite compellingly against that course of action. First, reputational. It's very, very difficult, actually, to return money to people if you've crowdfunded that money. It's very expensive. You can't give them back what they've paid to you. And if the litigation doesn't progress as you would like, it can be awkward, reputationally awkward, to tell people that you are both ditching the case that they have funded and that they can't have their money back either. I would find that reputationally very, very difficult. Second point is I think there's value of putting yourself in a position where you have to make an ongoing case for people to support your litigation. This is still a good idea because that feels to me like a very useful discipline. It creates the proper alignment between their interests as they perceive them and your interests as you perceive your own. The third point is that it encourages you to be less disciplined if you overraise than you might be if you were spending your own money about cost control. Slight side note, there are a few pieces of ongoing crowdfunding where people are raising money for only very vaguely specified bits of legal work, which, because they're only vaguely specified, are of indeterminate value to the people who are being asked to fund that litigation. I feel very uncomfortable about the propriety of those crowdfunding exercises and the premise upon which the lawyers who are getting paid from their fruits put their names to those exercises. And I'll talk about that a little bit in a few more moments. But leave that aside. Even if you have the capacity successfully to crowdfund, there is one very real problem that we're going to have to get to grips with, and that's what do you do about adverse costs? What do you do if you lose? It's very possible to seek to raise your own money by way of crowdfunding, your own fees. Depending upon how attractive your pitch is and the amount you're seeking to raise, you might succeed. You might also be able to raise a sum of money on account of the possibility that you lose, but you have a number of difficulties. Firstly, of course, you don't know what the other side's costs are going to be. You can't know what they will spend, and so you don't know how much you need to raise. And as I've just explained, there are difficulties of what to do with money if you over-raise. The second point is, if you don't raise, and you find yourself in a world where adverse costs matter, it's because you've lost or because you're throwing in the towel. That's not a world in which it's easy to raise adverse costs. Come and rescue me from the consequences of this foolish course, as we now know it, upon which I embarked, is a difficult pitch in crowdfunding terms. I haven't yet had to do it. The third point is that the other side's costs might far exceed any sum that which you may raise. So in the Uber case, matter of public record, I gave evidence, Uber didn't contradict it, that its value is about $70 billion US dollars. Its liability in that litigation exceeded £1 billion, and it was perfectly reasonable to anticipate that its costs at first instance alone, i.e. before any appeals, could top £1 million. Now there's no way in which I would be able to raise that sum of money to protect the general public interest in Uber paying the taxes that were due. The fourth difficulty is as I understand it, the case law on protective costs orders is just not designed for a world of crowdfunding. It looks to, in particular, what resources the claimant has in that litigation. But if you've raised money from 3,400 backers, that was the number who contributed to the Uber case, whose resources do you take into account in considering whether to make a protective costs order? If the answer is, well, you look at the claimants, that seems a little silly to me, because any one of those 3,400 people can be the claimant. You would just substitute somebody who has very few resources for somebody who has more. That's not an analytically sensible way of answering the question of whether or not somebody is sufficiently well resourced to be denied a protective costs order in crowdfunded litigation. Crowdfunding can't replace legal aid. If you have a very strong presence on social media and you're happy to leverage it to raise money, crowdfunding's a powerful tool. It's also very useful in governance terms. If you're going to stand at the front of a lecture theatre and make grand pronouncements about taking the law to where the people are, it's quite a good way of testing whether or not you're delivering on those grand pronouncements. Are you actually able to raise from funders the sums of money that you want to raise? So it's useful as a governance tool. If they won't give you the money, perhaps they're not where you expected them to be. But crowdfunding doesn't work so well for individual cases. If you don't have a media profile, you may still have very important issues that need to be protected. Typically, indeed, if you do have a strong individual profile, you're less likely to be dicked around by the system in ways that require that you take legal action to protect your interests. But even in that area where it works best of all, even in cases where there is a real public interest, those issues around adverse costs will need to be ironed out for it to be a really effective tool. I would very much like the governments to regulate in this sphere, but my expectation is that we're going to have to make common law in the field over the course of the next decade or so. Finally, because I want to leave some time for questions, let me just touch briefly on some ethical implications of working in this sphere. If there's anyone in this lecture theatre who has looked at my Twitter account, they will see that I attract, I would say, at least my fair share of criticism. Initially, that was pretty uncomfortable for me. Lawyers are not used to being so vigorously criticised in a public sphere. But I learnt that I had to accept that if I wanted to step into a different sphere of activity, into a political sphere of activity, I could not demand that the players in that sphere play by my rules. I can't insist upon that. Speaking for myself, I don't think that the fact of being vigorously criticised raises ethical considerations about my behaviour. The question is whether I'm behaving properly, not whether I'm being criticised by somebody. But I tell you this, being vigorously criticised in a public sphere does encourage you to be very thoughtful about your behaviour, because you know you will not be cut any slack if you get stuff wrong. And that, were you to want to dress it up pompously, as I very often do, you might describe also as being quite a useful governance tool. There are obviously also questions of political judgment about what cases you take, and I've discussed some of those issues, but they fundamentally are questions of judgment. They're not questions of ethics. If you get them wrong, people might say with justification that you are stupid, but I don't think they can say with justification that you are unethical. But there are obvious ethical considerations for any lawyers who ask people to fund a case. And it goes without saying that that is especially true if you are one of Her Majesty's counsel. In the language that you use when you promote a piece of crowd-funded litigation, there are embedded representations to people who may not be sophisticated in the fact that it is you who is asking them for that money. Whatever I say in a crowdfunding pitch about the prospects of a piece of litigation succeeding, the fact that it is me who is pitching for that money contains, as I put it a few moments ago, embedded representations about the prospects of that litigation succeeding. Those considerations are ethical considerations, and they are reputational considerations, and you have to be able to manage them both. It is not enough, it seems to me, for you simply to say this litigation is speculative. You have to go beyond that. You have to ask yourself whether you are satisfied that it is right to ask people to fund this litigation. You cannot put that judgment on them. It's also true if you are a lawyer who is the beneficiary of a crowdfunding exercise. So I've not taken a penny from any of the cases that I funded. I don't even recover my direct expenses. I had to go to Dublin a couple of times in that litigation, and I did not seek to recover the costs of doing so from the crowdfunded monies. If you are a lawyer who is a beneficiary of a crowdfunding exercise, I think you have to engage with the ethics of that exercise in a much more active way than you might do if you were a normal client. There's an interesting question here for a trust lawyer, I'm not a trust lawyer, about who owns money that is crowdfunded. But fundamentally, whatever its legal status, it needs to be carefully stewarded as if you owned it. And that's difficult if it isn't meaningfully the steward's money. You have a sense when this money comes in that it exists for a purpose, but it doesn't really have an owner in any meaningful sense. And if you are the lawyer who is benefiting from that money, it seems to me you need to be very, very thoughtful about what you do with that money. And those issues are particularly stark in cases where the work is open-ended. The issue is one that people feel very profoundly about, and where you have an unsophisticated promoter who is pretending to be the client and who is not spending his or her own money. The sort of, do you care about this incredibly important issue, then give money to fund this valuable legal work type of pitch. The lawyer who is going to enjoy in fees the benefit of that crowdfunding exercise is meaningfully both the client and the solicitor of money that isn't meaningfully owned by anybody. And that feels to me like a profoundly uncomfortable situation to find yourself in. The last point I want to mention is the long-standing and very familiar debate around judicial activism. It's an important debate, and the closer you sail to the political wind, the more obvious is the need to have regard to where the line is drawn. The rule of law is both a bulwark against public opinion, but is also contingent on public opinion. And as a judge, you have to be very, very mindful of that. That's a rather curious thing to say, so let me just put a little bit of flesh on those bones. When I read the decision of the High Court and the Supreme Court in Gina Miller's case, I was acutely conscious of both of those aspects of the rule of law, that it was bulwark against the public opinion that was very hostile to the notion of Parliament voting, but it was also contingent on public opinion in the sense that I read that judgment as doing things that a court would not have done had it not felt that the rule of law was at that precise moment in jeopardy. So as a judge, you have to be very mindful of that. You have to be mindful of it if you want to preserve the operation of the rule of law. Thank you very much for listening. That's all I want to say. I'm very, very happy to take questions about virtually anything.